role of agency or the agency contract. An agent is a person employed expressly or impliedly to do any act for or in representation of a third party. The person on whose behalf he acts is the principal. Therefore, agency can be defined as the relationship that exists when a principal appoints another person known as an agent to transact on his behalf with a third party. Classification of agents. One of the classification of agents is general agent. He is the agent engaged to perform a particular task on behalf of the principal in ordinary course of his trade or profession as an agent. We also have special agent. This is an agent whose authority is restricted to the performance of particular transaction, not being in the ordinary course of trade or profession. Specific agent. This is an agent who has neither possession of good nor document of title but engaged to make bargaining or contracts. Factor agent. This is an agent entrusted with possession and sale of good in his name. Auctioneers. This is an agent licensed by state to sell goods and other property by public auction. He may or may not be entrusted with possession of good but is an agent of both parties. Creation of agency relationship. Agency relationship can be created through agreement. This is the relationship between the principal and his agent. It is normally consented. However, no one can be an agent of a principal without principal consent. Agency by estoppel. Estoppel means that a person has allowed another to believe that certain affair exists. Therefore, the principal believes that the agent will act on good faith in his behalf with a third party. Agency by ratification. It is an agency that occurs when the agent acts on behalf of the principal without prior authorization by the principal. However, ratification by the principal gives validity to the agent to be authorized act as from the date of ratification and not from the principal when the principal ratifies. Agency by necessity. It is an implied agency where a person acts on behalf of another out of necessity caused by emergency. There must be a genuine emergency where it is not possible to communicate to the principal and get instructions. Agency by cohabitation. It is an implied agency where marriage plays a central role, where principal and agent can be presumed to be husband and wife respectively, where wife is presumed to pledge her husband credit for necessaries. It is applicable as long as they are living together. Types of authority. In agency contract or in agency relationship, we have actual authority. It is authority which the agent has been given by the principal under the contract between them. It can be either express, implied, or customed. We also have apparent or ostensible authority. It is authority which the agent has not been given by the principal, but which he appears to have by the reason of principal conduct. It is also created or exercised by agency by estoppel. Presumed authority. It is authority which is not given to the agent nor based by estoppel. It is the agency created also by operational law or necessity or cohabitation. Duties of the agent. One of the duties of the agent is the duty of performance. The agent is required to perform his obligation if the agency is contractual. However, he is not bound to perform if the agency is not created by agreement or where the undertaking is illegal or void. Also, the agent is required to be obedient. The agent is bound to obey the principal instruction. That means that he must act within the scope of his authority. The agent is also required to offer due care and skill. The agent must exhibit due care and skill appropriate to the circumstance at hand. Another duty of the agent is duty of maintaining accounts. The agent must explain to the principal the application of money or good that comes into his hand during the relationship. The agent is also required to be bona fide. As a fiduciary, the agent is bound to act in good faith of the principal, and his action must be guided by the principle of fairness. The agent is also required to inform the principal The agent must ensure that the principal is well aware of the transaction entered to. The agent must also maintain secrecy and confidentiality. The agent must not dispose his dealing with third party without the principal consent. The agent should also maintain separate accounts. The agent must maintain separate accounts of his money and asset with those of the principal. Some of the duties of the principal is the duty of indemnity. It is the duty of the principal to compensate the agent for the loss or liability arising where the agent acts within the scope of his authority. The principal also starts the duty of remuneration. It is the duty of the principal to remunerate the agent for the service rendered. The other duty of the agent is duty of personal performance, which we will cover as a subtopic. So personal performance as a duty of the agent. The agents must perform the other personalities as it is consistent with the maximum of non-post delegate, or delegates must not delegate. However, the maximum is subjected to various exceptions where the delegates can delegate. Exception where the agent can delegate powers is where it is authorized by the contract. This is where the act is authorized by the contract between the parties. Agreement, authorized by the law. This is where the performance is enforceable, hence authorized by the law. Principal knowledge, this is where he delegates with effect on principal consent. Emergency, this is where the performance is based on an unprompt event that has occurred. Special skills, this is where some special skills are required which the delegated does not have. Authorized by trade, this is where the performance is authorized by the trade usage or custom. Necessary act, this is where the act is necessary for the performance. Some of the remedies of the principal towards the agent is remedies of dismissal. The principal is entitled to dismiss agent for misconduct. If the agent has acted fraudulently, the principal has the complete defense against remuneration or indemnity of the principal for any loss, right to sue. The principal may institute certain action against the agent where appropriate, for instance where the agent breach the agency contract or misappropriate the agency property or resources. Some of the remedies given to the agent or the right of agent to add a defective principal. One of them is right to sue. If the principal fails to remunerate or indemnify the agent has an action of damage for breach of the contract. Right of lien. An agent in possession of principal goods is entitled to retain them as security for any obligation owed by the principal. Right to stoppage in transaction. An agent who parted with possession of goods is entitled to resume the same. However, if the goods are still in transit to the principal, thereby enabling him to exercise lien on them, this is where the agent can stop the delivery of some goods or material fact to the principal if he requires the principal to perform a certain specific performance. Withholding of passing property. This is where property in good has not passed to the principal. The agent is entitled to withhold the passage of goods to compel the principal to perform any obligation owing. There are some of the liability of the principal. So let us enter into a topic where we shall cover the liability of the principal. As a general rule, the principal is liable for breach of contract and tort committed by the agent within the scope of his authority. The principal may also be held liable for crime committed by the agent in certain circumstances, for instance, crime of strict liability, where a principal uses agent to commit crime. In agency contracts, the principal may be named. If his identity is disclosed to the third party, he may be disclosed if his existence is made known to the third party, or undisclosed if his existence is not made known to the third party. As a general rule, the principal is generally liable whether undisclosed, disclosed, or named, and may sue or may be sued by the third party. However, if the agent signs a contract without disclosing the agency, the principal ceases to be liable. So that one renders the agent to fall under the personal liability of the agent, or exemption to the general rule where the principal must be liable. This is where the agent expressly or impliedly consent to personal liability. Also, the principal can act where the agent exceeds his authority. It can also act when the agent negligently or recklessly fails to indicate in the agency. The personal liability of the agent can take place where the agent executes a deed in his own name, where the agent acts for a principal who does not exist and does not have the capacity to contract, where the agent executes a deed in principal absence in case the circumstance in which he is appointed was not by deed. There are various ways in which an agency can be terminated. An agency contract can be terminated through agreement. The parties may enter into a new agreement to discharge the agency contract. So both parties, the principal and the agent, can agree to terminate the agency contract or commence the agency contract, withdraw consent. The agent and the principal may revoke the agency by consenting to terminate the relationship. Also, the agency contract can terminate through death. Death of a principal or agent may terminate the agency relationship, since the agency relationship must be created between two parties, the agent and the principal. Performance. Execution of agent's authority in full terminates the relationship as the obligation has been discharged. So after discharge, the contract becomes executed, and therefore they can terminate the agency contract or create a new one. Lapse of time. An agency relationship terminates on expiration of duration stipulated by the usage or custom. Insanity. The unsoundness of party terminates the agency relationship since the party loses its contractual capacity. Destruction of subject matter. If the foundation of agency is destroyed, the relationship terminates since the subject matter of the contract has been violated. Frustration of the contract. Agency created by agreement comes to an end when the contract is frustrated or the contract becomes impossible to implement. Thank you for watching. Kindly remember to support me by only smashing the red button so that you will not miss out any of my future content like this. Thank you. We shall also make a video covering broadly how an agency relationship can be created. Kindly, I'll put the link in the end screen and also in the card above the video. Thank you.